Good morning, everybody. Happy Thursday, which is technically kind of like Friday this week. Welcome to the Courtroom Files Live. Let's start the day with Judge Simpson.
We're going to be requesting a brief adjournment. My client, I believe, is due to get out on the 7th. Able to contact him. So
He's what?
I believe he's due to get out on the 7th. Is that correct, Mr. Schultz?
Yes.
You're getting out on the 7th.
Yes.
So do you want you don't want the 10th, you want the 17th?
That would work better, Your Honor, please.
Without objection, probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
We'll be in touch, Mr. Schultz.
All right.
Court does call the case of the People versus Hector Gonzalez. Did I wake you? No, go ahead.
Not yet. Your Honor, not yet. Mr. Gonzalez, come forward. Stand here. Tell the judge your name. Michael Vincent on behalf of Mr. Gonzalez.
Hector Gonzalez, Your Honor.
See you, Mr. Benson. I haven't seen you for a while.
Lucky you.
Yes,
May I approach with the prosecutor?
do it. Yes.
And just that quick, that judge is taking a time out. Let's go over to Judge Middleton.
I'll agree with you. I was surprised. I didn't hear nothing about the circus either, and I live in Sturgis.
Well, that might have been something I might have gone to see. I like the idea of a small traveling circus. At any rate, sir, you got charged with no insurance. We get lots of these. We have several today. They can now run your license plate and they tell whether you have insurance or not. The way this is charged, it's not under the motor vehicle code, it's under the insurance code. And it's a misdemeanor and it's punishable by up to a year in jail, fine of up to $500 and not less than $200 plus cost. Do you have insurance now?
No, but I do have my girlfriend's vehicle that I can drive since I only work 2 blocks away. So until I get insurance on it, I don't have to drive it.
Mr. Stickley, one option would be to adjourn this for a while to have him come back with proof of insurance and then the prosecutor might be inclined to reduce it.
That would be my recommendation if he was.
Let's talk about this, Mr. Grams. This charge is expensive. It's punishable by up to a year in jail and requires you get fingerprinted. The minimum fine is $325. There's a lesser charge called no proof of insurance, and I always do this, but it means you didn't have a little slip in the car. That's a civil infraction. It's punishable by a fine only. And if you come in and show that you have insured the vehicle, the prosecutor almost always will reduce the charge to the civil infraction. The goal is just to get people insured. And I'll give you a heads up, it's super expensive. You get an accident and you don't have any insurance because the other guy's insurance company is going to sue you for thousands of dollars. Happens about 20 times a year. So do you plan to get insurance on the vehicle?
Absolutely. And if you guys did offer that, I appreciate it and go forward with that. Yeah.
All right, so let's adjourn this.
The only, as far as coming back to show it, would it be at a time where I wouldn't have to miss work or would I?
Well, that's a question. I was just gonna ask that. Are you missing work right now?
No, yeah, but I got vacation. I got vacation time, so it's not a big deal.
Well, I have to set it
couple hours
Thursday
off.
Morning. So where do you work?
Sturgis in Parmatube. If it's something like in the morning, I can shoot over,
All right.
pay it
we'll
2
do-
hours,
we'll-
just take 2 hours.
we'll
That'd
do
be
that.
perfect. Awesome.
Let's set it for, I won't be here that day, August 7th.
Okay, it gives me 1 month to get it. That's awesome. I appreciate that, Judge.
Yeah, like I said, the goal is to help people get insurance.
Instead of just paying the fine and then coming
Yeah,
back
and then they're
6
still
months
driving
later.
around with no insurance. So this makes more sense. You know, if you pay the fine, you go, then the money you just paid me, you don't have to pay for insurance. This often comes with an improper plate. I call it driving while poor. People didn't have the money to renew their insurance or get a plate, and they're driving anyway. But this makes more sense. It helps make sure that people get insured. It'll be a Thursday, August 7th. At 8:30. Bring proof of insurance. That alone might save you about $175. So put that on your refrigerator. Come back with your insurance, whether you meet with a prosecutor, and hopefully they'll be able to work something out with you. All right, you're good to go, sir.
Thank you. Appreciate it.
Is your shop shut down for the holiday?
Tomorrow. Actually, I'm going back to work right now
All
since
right.
I've got out early. Thank you very much.
All right, good luck, sir.
Appreciate that.
All right, well,
Barbara, thank you for the 10. Very generous of you. Wonderful way to start the day. Very much appreciate it. Let's go back to Judge Simpson as he is back in session.
Bond will continue.
Thank you, Rob.
Court calls the case of the People versus Virgil Dunlap.
Andrew Children, check out That's Mr. Brutus.
Virgil Dunlap. We have Miss Yagi listed, so.
Can't flick it up if it takes you.
Pardon?
We can flip it off.
Okay.
I believe we're looking for Mr. Drukas right now, Your Honor.
That's it. Court calls case of People versus Ibrahima.
Ashley, thank you for gifting 20 memberships. Incredibly generous of you. You continue to amaze me. Your generosity is something special. And I think the community recognizes how special you are as well. So thank you so much.
Judge, good morning. I was appointed on his home invasion third matter on 23 F10699.
10699.
Yeah, last night about 7 o'clock.
Informed me that I usually have an interpreter.
You understand? No, you understand English, correct? Is that a yes? Is that a yes?
Yes.
Okay,
So he does not need an interpreter.
I don't believe.
Do you need an interpreter?
No.
No, Your Honor.
All right. What are we doing on these?
Your Honor, we're asking for an adjournment.
Yes, Your Honor.
All three matters.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond in these matters will continue.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Court does call the case of the People versus Tanya Hall.
Good morning, Your Honor. Calvin Hawthorne for the People.
Good morning, Your Honor. Just go on back to Ms. Hall. Judge, is Ms. Hall here? Judge, as you know, Ms. Hall is an elderly lady. She lives at the Delana Center. I have no phone. I have no email. I would ask the court, you being the compassionate judge you are, if you would adjourn this 1 week. I will go.
We received a communication from Community Corrections indicating that your client presumably left a voicemail, or a woman, that Ms. Hall was in the hospital. She then received an email stating that she was discharged from the hospital. So I don't know why she's not here.
Judge, you know, I believe you know her circumstances. Would you give me 1 week? I will go to Delana Center and inform her. I have no other means of communication.
Bench warrant will issue for defendant's failure to appear. Bond just setting him on a $10,000 cash surety. I won't have the warrant issue until the 8th. Give you time to try to find her.
Thank you, Judge. Appreciate it. Have a good tour.
I will be. Court does call the case of the people versus Anthony Turner.
Honor, the person they had waiting was not Mr. Turner. I do believe they're gonna go back and get Mr. Turner now. I don't know who the individual was standing there, but Stephanie Cannon on behalf of Mr. Turner. Okay. Oh, where are you? Your Honor, we are asking for an adjournment. He has been screened for mental health court. We're just waiting for the evaluation. Hopefully with that, the prosecutor and I can come to a resolution. We are waiting for it. They have to give it to us.
Would the 17th be enough time? You need one more week.
Your Honor, they indicated that they were going to try to get it to me today. When I checked, it was not there. So that should be fine.
Give you two alternatives. That should be fine.
Whichever
July
one,
17th, July 17th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Court calls case of the people versus Mary Collins.
Honor, Christina Berry, requesting petition charges for rule 8.120 under the supervision of the exactly.
Practice is granted.
Thank you, Your Honor. Christina Berry.
Kyle Burrell on behalf of Mary Collins. Ms. Collins, please say your name.
I'm Mary Colley.
Just so you understand, is a date and time set for probable cause conference. I have been speaking with EPA Ward on this morning about trying to come to some sort of resolution. We're asking for a 1 month adjournment here to let Ms. Collins.
1 month. Why do you need one month?
Which is basically to Ms. Collins basically needs to earn an offer at this point. And so we're giving her some time to provide that material and provide that proof. We can do less if the court.
You're going to do whatever I say, but I'm just trying to figure out why you may need it.
Your Honor, I talked to Mr. Bedell about providing mitigation information. I was thinking that could happen in the circuit court or down here, but we have to keep things moving, so I defer to the court.
And if the court would like to see it sooner, we can do that as well.
July 24, 2025, 9 a.m. Bond continued.
Thank you, Judge. Welcome to talk to you in the hallway.
Thank you.
Thank you, Judge.
Court calls the case of the people versus Sean Newcomb.
Maybe Richmond looking for the people. Like about appearing with and on behalf of Sean Newcomb.
Please state your name for the record.
Sean Newcomb.
Has the court received the evaluations from the forensic?
I have.
We have nothing further to present in this matter. Set an order finding him competent.
Based upon a review of that report and the evidence submitted, the court would find that the defendant is at this time competent to stand trial, which specifically find that the defendant can understand the nature and objects of the proceedings against him and rationally assist in his defense. Therefore, the defendant is deemed competent. Do I have an order?
Yes, we've sent an order finding him competent.
When did you send the order?
Earlier today.
Oh, this morning in the middle of this docket.
Before the
So
docket.
right now we really don't have an order.
Before the docket.
I have to have my staff pull it off
Yes, Your Honor.
and stop everything to have it happen. Do you?
Oh, there you go.
What do you mean, there you go? You sent it this morning. Really? 9:12, even after the docket time start. Did Brown tell you to do that? He did, didn't
No, Your Honor, I did it.
he? You don't have to fall on a sword for him. All right, I signed the order that came in late.
Thank
All
you,
right.
Your Honor. We would like to set this matter for PCC.
Set a probable cause conference with 2 weeks be enough time for it. Set a probable cause conference July 17th, 2024, 9 a.m. Bond will continue.
Barbara, thank you for the 5, and you're absolutely correct. It's because YouTube wants 30%. Spot on. But thank you so much. Appreciate it.
Morning, Judge Cabral, on behalf of Ms. Hafner. He's approaching the podium. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
And Your Honor, I was just very recently appointed on this matter. We are asking for a brief adjournment at this time.
July 17th, 2025, 9 a.m. Bond continued.
Thank you. Judge, if the defense may be heard as to bond.
She's out. 17th.
Thank you, Judge. So Ms. Hafner currently has a no contact order with her children. 2 of her children have a bad hereditary condition that requires constant and fairly advanced medical treatment. There could be a hospitalization or I believe you said a surgery sort of at any given time. Name of the disease was too complicated and long for me to even write down here, but we are asking for a modification to the no contact order to allow supervised contact for the purposes of medical treatment only.
Response from the people.
We would ask that the bond remain set where it is until we can have an exam or resolve the case.
I mean, is CPS involved?
Yes, Your Honor.
Has CPS?
I'm looking, a referral was complete at the time of this investigation.
Right.
They're pacing it.
How many children are involved in this one?
Elijah appears to be the victim.
There's only one child named in the complaint, Judge, yes.
As far as the victim. I mean, I'm concerned, Your Honor, when the police came to investigate, the defendant took a long time to answer the door. She said that he was sleeping and they needed to check the welfare of Elijah. He was in his bed covered with a blanket, but not sleeping. They immediately observed blood coming from his face as well as tears from his eyes and blood touching. So we would ask that bond continue. I don't think it's appropriate for her to contact with any patient.
And if, for what it's worth, Your Honor, Elijah is not one of the children that has the condition.
Well, but I'm not, you know what, I tell you what, I'm not going to change this, and I'm not going to change this on the fly, certainly. If you believe that it should be changed, file a written motion, I'll hear it, but I'm not going to do that. Motion for bond reduction is denied at this time, or bond modification is denied.
Understood. Thank you, Judge.
Court calls case of the people versus Thomas Bash.
All right, well, the next contestant comes up. Good morning once again, everybody. Welcome to the Courtroom Files Live. And again, another thank you to the generosity that's already out there today. It never ceases to amaze me. And as indicated in the poll, where your only option is to give me some version of, yes, this is the best community in LawTube. So if you're new here, welcome. Stick around a while. You'll like it here, trust me. Reminder, it is movie day in the chat today. We've done TV shows this week. We did music yesterday. So today, feel free to discuss movies. I will tell you the courts are busier than I thought they would be, so that's good. But we can discuss movies as well. And I'm going to throw mine out there right away. My mostest favoriteest movie of all time, Dr. Strangelove. I love me some good Stanley Kubrick, and that one is my all-time favorite. But feel free to join in.
Your Honor.
Did you fill out a plea form? Even though it's the stated count, I've got to have the plea form.
Okay. I was under the impression that the plea form didn't need to be filled because it was already on there, but we can fill it out, Your Honor.
That. Also, it's a stated count because the changes, but the defendant has to acknowledge you need to fill out a plea form. I don't care whether it's stated.
Understood.
I'll pass it. Thank you. Court calls case People versus Bianca Rao.
People.
Hi. He went out.
Good morning. What's your name?
Bianca Rao.
Where's Mr. Burdell?
Went out.
Seriously.
On behalf of Ms. Rowland, my apologies, Judge. Ms. Rowland, have you stated your name? Okay. So, Your Honor, today is the date and time set for probable cause conference. I have given quite a bit of mitigation documents to the prosecutor. It's my understanding they need a little more time to review that. And so we are asking for a brief adjournment.
July 17th, 2025, 9 a.m.
Thank you, Judge. We'll talk out in the hallway with you.
Cases of the people versus Todd Raber.
And for others, for the people?
Assistant Public Defender Jay Ballinger on all cases not ending in 0891, Your Honor.
Kyle Burdellen, the only case ending in 0891. Have you got the phone for this one, phone number? Thank you, sir. Thank you, sir.
Apparently, I didn't even know that. Can you state your name for the record, sir?
Todd Rayburn.
All right, what are we doing?
Your Honor, yesterday I submitted an order for the court, a stipulated order for the court. My understanding is that all other orders are signed for him in an effort for him to go to treatment. My belief is that these are the only two cases that I submitted to the court, the stipulated order for, that he does not have an order signed in order for him to go to treatment. We were asking.
Sign the order.
I'm sorry?
I've signed the order.
Okay. We were just asking for a 3-week adjournment in an effort to get him into treatment and track his progress.
Mr. Burdell.
Judge, the defense moves into would join that motion on my case as well.
Probable cause conference, July 24th, 2025, 9 a.m. on Will.
Thank you, Your Honor.
Yeah. Court does call the case of the people versus Taylor Adams.
We're ready in this matter, Your Honor. John Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Taylor Adams. Mr. Adams, could you please state your name for the record?
Taylor Adams. Thank you.
Your Honor, today is the date and time set for a probable cause conference. We have made great strides in working out a plea agreement. However, there's still some further information that we'd like to provide to the prosecution. So we'd ask for a 1 or 2 week adjournment so that can take place.
Probable cause conference without objection, July 17th, 2025, 9 a.m. on.
Thank you very much.
Thank you, sir. Thank you.
July 7th.
Court calls case of the people versus Brooke Bailey.
Assistant Public Defender Jay Bellinger on behalf of Ms. Bailey. Ms. Bailey, can you please state your name for the record?
Brooke Bailey.
Your Honor.
She's waiving.
Yes, she is.
Ma'am, you're waiving your right to a preliminary examination.
Say yes.
Yeah, yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right. Preliminary examination having been waived, defendant found over to circuit court on a single count.
We acknowledge receipt of information, wait formal reading, stand mute at this time, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 22nd, 2025.
Perfect.
At 1:30 with Judge.
July 22nd, 2025, 1:30 before Judge Conte. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case people versus Abdul Rahman Adaliyah. I messed it up again. But we'll get it.
And Alex Warren Green on behalf of Mr. Al-Dayef. Could you please state your name for the record?
Abdurrahman Al-Dayef.
Exactly what I said.
Your Honor, today's date and time for probable cause conference. At this time, we are requesting an adjournment to complete media discovery.
To do what?
To complete media discovery, Your Honor.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the people versus Quincy Jones.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Jones on case ending 0697.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones in case 21574.
Okay, in both cases, I have an indication that there are plea agreement form that he is going to be guilty to an added count 2 of use of a controlled substance in both matters, a 1-year offense upon a successful plea with those charges count 1 in each case.
That is correct, Your Honor.
That is correct, Your Honor. I have gone over his rights with him.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me God, yes.
State your name.
Quincy Jones. All right. Sir, it is this court's understanding that you're going to be pleading to 2 counts of use of a controlled substance. All right. Is that correct?
Yes, Your Honor.
Those are misdemeanors, punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
I understand.
You understand also in one of the cases, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance contained in case ending in 0697, how do you plead?
Guilty.
To that same charge contained in case ending in 0574, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights?
No, I read them thoroughly.
Pardon?
I read them thoroughly.
You understand them?
Yes, I do.
All right. So you have no questions?
No questions.
Is anybody? I think we look at paragraph 5, excuse me. Copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
He's asking if anyone's made you any promises beyond.
No. Anybody threaten you or coerce you in any way?
No, they haven't.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of these offenses?
Yes, I am guilty of these offenses.
Okay. Starting with the case in the 14A2 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I had.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, I did.
All right. Sir, I need you to also understand that if I accept your plea and between the time of sentencing and the time of between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule, and would it be proper to accept the defendant's plea?
We were satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count one is dismissed. In the 1482 matter, pre-sentence investigation and report is ordered at 1482 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address bond?
I knew it. I was trying to sneak it in before you said something, Rushy. In the other matter, let me just finish up the other matter. In the other case, defendant is count, if I didn't say so. No, count one is dismissed, except the plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 1481 probation. Sentencing will be
July 30th, 2025 at 12 p.m.
no. I have a sentencing. 9th, he's in custody. That's the date we'll give. July 9th, 2025. Time?
9 a.m.
9 a.m. So you can come here and then get over to Judge Barr, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor, but Your Honor,
it wasn't just he didn't go to community corrections. Isn't that correct?
that was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Yeah, he probably came down off all those drugs. Go ahead.
Well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at his sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor, consider reducing this down to a personal bond.
Your Honor, I would just add that I have been in touch with the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and happy to fill in Ms. Rushing as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else may have been in his system. The concern that people added to that is that prior to that, Eric's in court under the influence, Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of staying for using drugs. And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I would prefer that he at least remain in custody until his sentencing on July 9th.
All right. Until I have an additional evaluation, I'm going to deny the request for any type of bond reduction. Defendant bond will continue in each court.
Thank you. Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Court calls the case, People versus Elton Bell. Oh, boy.
Good morning, Judge. Kerma Dadush on behalf of Mr. Bell, not with. Mr. Bell is 65 and is not able to drive. He had a ride who was supposed to bring him here. He told me he's
If
trying.
you say he's coming on a bus, I'm coming up.
He's not, I don't even think he can navigate a bus. Not because of, he's just, I even tried to get him on Zoom. I don't think he can navigate that either. I would have gone down that route knowing he does not have a ride, a consistent ride. In any case, Your Honor, can we please pass on this?
You want me to pass it?
Yes, please. I'm
Okay.
trying to find
And what's
another.
going to happen?
When he
Between-
comes? Oh, he's finding another ride. He's appeared every time before, Your Honor. I believe it's his first time not appearing. I can get him to send photos of a bus.
Of what? You know what?
If that would
You know
be
what?
help.
I'll pass it.
Thank you, Your Honor. Thank you, Your Honor.
Wow. Court calls the case, People versus Rahman Muhammad.
Andrew Childers of Graham on behalf of the people.
Kyle Bedell on behalf of Mr. Muhammad. Mr. Muhammad, please state your name.
Rahman Muhammad.
And Your Honor, may we approach briefly? Very briefly.
Yes.
Thank you, Judge.
All right, well, they approach. Let's change it up. Since we're talking about Ashley, let's go to Ashley's backyard. This is Fulton County, Georgia, where they're working their all-purpose calendar.
We would ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. That'll be all for the state.
And we do stipulate, Ms. Harrison, I apologize, the victim in count 3 is his child, which is, the mom is the victim in count 2, so I'm asking no further violent contact.
Yeah, sure. Mr. Haddad, we agree to no further violent contact.
Thank you.
So this, Major Weller, that's the mother or the child?
That's the child, Your Honor.
Judge, my client, Mr. Weller and Ms. Taylor have a child together. And Mr. Weller is my client's child with Ms. Taylor.
Okay.
Oh, no, Your Honor, I believe you need to swear my client before we proceed with questions.
All right. And so, Mr. Weller, I understand that you wish to plead guilty today? Okay. And so, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. I'm going to ask you a series of questions to make sure you understand the plea that you're taking today. The first question I have is that are you under the influence of any unprescribed medication, drugs, or alcohol at this time that would impair your understanding of the plea today?
No.
All right. Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up or waiving your rights to the presumption of innocence?
Yes.
And that you're, excuse me, and that you're also giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you would receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're on probation, your probation could be affected or revoked because of this guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right. And as to the charge of battery and simple battery, which merge in a second count of simple battery, how do you plead?
Yes.
All right. And you understand the conditions of your plea arrangement, correct?
Yes.
All right. No further violent contact.
Yes, ma'am.
All right. That will conclude. I will accept the plea.
Thank you, Judge.
Okay.
We can do position number 1, Mr. Bostic.
Okay.
So guys, we're not going to go there yet, maybe later today, but I did want to point out over in Dungeon Court, you'll notice on the back right of the screen that the light that had been out for a week is now lit again. So it appears they have met their quota of damned souls that allow that light to once again be lit. So I just thought I'd share. Let's go back to Fulton County.
June 19th, 2025 until today. Balance probated. Stay away from the CBS located at 3221 Peachtree Road in Atlanta. 40 hours of community service, and we do agree with the defendant going non-reporting after he has completed the community service condition. We do ask that the defense stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Okay.
So stipulated, Judge. We just ask you to accept the pleas negotiated and allow his probation to go non-reporting.
All right. That'll be fine. All right. And so, Mr. Bostic, I understand that you wish to plead guilty this morning. Is that correct?
Ma'am, you want to plead guilty?
I understand that you wish to plead guilty. Can you hear me?
You wish to plead guilty? You want to plead guilty today and resolve the case, getting time served?
Yes, yes.
Okay, you need to answer the.
Yes, I do.
All right, I need to ask you a series of questions, sir, to make sure you understand the plea that you're taking today. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
Okay, put your hand down for me. Are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would impair your understanding?
No, I'm not.
All right. Are you satisfied with the services and representation of your attorney?
No, I'm not.
Are you satisfied with your lawyer? He's asking if you're happy with your lawyer, with the plea. Are you happy with your lawyer, with the plea that you got? That's what she's asking.
Oh, yes, I am. Yes. Yeah.
Okay. And do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, I understand, yes.
All right. Are you giving up the right to remain silent and not testify against yourself?
Yes, I understand.
Okay. And you understand that you're agreeing to waive these rights today. Is that correct?
Yeah.
Has anyone promised you anything to plead guilty?
No, they haven't.
Okay. Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, they haven't.
All right. And you understand that if you're on probation, that could be affected by your guilty plea today.
Yeah, I understand.
Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of this charge against you?
Yeah.
All right. And you understand the conditions of the plea. What you have to do, you have to stay away from that CVS on Peachtree Road. You understand that?
Yeah, I understand.
Okay, you've got to stay away from there, and you have 40 hours of community service, I believe.
Yes, Your Honor.
Yeah.
All right. I will accept the guilty plea.
Thank you, Your Honor.
All right.
Position number 29, Mr. Kicklighter.
I'm sorry, just for confirmation, this does go non-reporting, Judge, correct?
I see non-reporting after completion of his community service, yes.
That is correct.
Thank you.
And this is position 2?
29.
Oh, I'm sorry. This is 16 CR 008248C, Stephen Young. Is that correct?
No, Judge, this is position 29.
Oh, I'm sorry. I thought she said 49. 29. $25 CR 003417E, Frederick Kicklighter, maybe.
That is correct, Judge.
All right. 1 count of giving false information to law enforcement.
Yes, Judge.
All right, State.
Yes, Your Honor. The state's recommendation is time served. 32 days credit for time served is 16 days. The defendant has been incarcerated since June 18th. And we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. That'll be all for the state, Your Honor.
We stipulate, Judge. Thank you.
All right. So, Mr. Kicklighter, you would like to plead guilty today. Is that correct?
Yes, ma'am.
And that's a time served plea, correct?
That is, Judge.
All right. Just ask you a few questions and make sure you understand the plea that you're entering into today. Okay.
Okay.
All right. Are you presently under the influence of any unprescribed medication, alcohol, drugs at this time that would impair your understanding?
No.
Are you satisfied with the services and representation of your attorney?
I am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
I understand.
And that you're giving up the right to trial by judge or jury, whichever you prefer?
I understand.
All right. And so, has anyone promised anything to plead guilty?
No,
Has anyone told you that you receive a lesser sentence for pleading guilty?
no,
Okay. And that you understand that if you're currently on probation, that could be affected by your plea?
I understand.
All right. And you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
I do.
All right. I will accept your plea.
Thank you, Judge.
All right.
Position number 34.
Okay.
Let's switch it up. Let's go to Miami-Dade. This is Andrea Ricker-Wolfson sitting in for Judge Grumpy Pants yet again today.
And the stay away order they'll deal with in division. Tasha Posse. All right, good morning, ma'am. You're charged with retail theft. This looks like it's the co-defendant of the previous one. So the court finds cause for F.
Oh, actually, she's got a fugitive of corrections, right?
And she has a fugitive, no bond from Broward County.
Okay. Bond is going to be set at 2,500. And you are to stay away from the DSW at 19135 Biscayne Boulevard. Do you understand? I can't hear it.
Yes, ma'am. Yes.
Okay. Jarvis Winkfield.
Your Honor, he was on house arrest. These are added charges.
Right, so he needs to see his judge on Monday since he violated the house arrest by picking up a new case.
Is he here?
Your Honor, I'm sorry for Miss Tesha Pause. What was the bond?
2,500. And do we have Winkfield?
Present.
Morning, sir. This an added charge?
Yes, Your Honor, he was on house arrest. He picked up this charge.
So not really added, he was out. He should
Yes.
see the judge on Monday.
On the house arrest case. You're charged with possession of controlled substance and tampering with physical evidence. Court finds probable cause. Bond is set on count 1 at 2,500, count 2, 2,500. Good luck to you, sir.
Is there a hold?
And a hold on the one that you said house arrest. Do you want to put that case number on the record?
It's multiple cases. It's F25 9314, 9315, 9371, 9313A, 9303.
All right, good luck to you, sir. Jose Lopez. Does Mr. Lopez speak English?
No, Mr. Lopez is a bond out.
Oh, okay. Thank you. Jonathan Cuellar,
Yes, ma'am.
and he speaks English. Good morning.
Good
You're-
morning, ma'am.
Theft, third degree, and petty theft.
Defendant has priors out of county. He was released from prison in August. It was Broward County burglaries and theft, requesting a bond.
The court finds probable cause. Bond on count 1 is 2,500, count 2 is 500, and you're to stay away from the DSW at 19135 Biscayne Boulevard.
Your Honor, are you elevating count 2? It says 150.
No, I'm not. Sorry, I misread it. 150 on count 2. Thank you for pointing that out. Do you understand the stay away order, Mr. Cuellar?
Yes, ma'am. I'm no longer allowed to return to the DSW on 191, ma'am.
That's right. Good luck to you, sir. Luis Sanchez.
May qualify for TAP.
I did. Sorry about that. Mr. Sanchez there?
We're getting him, Judge.
Your Honor, did we request a Creole interpreter? She's trying to get in.
Okay,
Let me see. You did request a Creole interpreter.
you got it. Is that?
I'm trying to look for the Creole interpreter. Who is it? Oh, I see, Mr. Dinash. Promoter.
Mr. Lopez, I mean, excuse me, Mr. Sanchez, do you speak English?
No.
No.
All right, you're charged with petty theft, 2 or more convictions.
Está usted acusado de hurto menor y de 2 condenas, 2 o más condenas.
The court finds probable cause.
Dice la juez que sí hay motivos fundados
Going to be TAP with an alternate 2,500.
y va a ser el programa TAP, la super libertad condicional bajo ese programa, $2,500 de fianza.
And a stay away order from Target
Y una orden de alejamiento de Target
at 3401 North Miami Avenue.
en el 3401 de la avenida North Miami.
You understand?
¿Ha entendido que tiene que mantenerse alejado de ahí?
Sí.
Yes.
Good luck to you, sir.
Buena suerte, caballero.
Gracias.
Thank you.
Dennis Chavez.
Yeah. How you doing, Your Honor?
Let's take a brief detour, even though I have it labeled wrong. This really isn't Dungeon Court. This is Michael Groff's channel. This is the video he just posted. Just give it a listen for a minute.
Just down the street from Studio B here, about 1/10 of an inch of rain, but here officially at Studio B, we had almost an inch of rain. I mean, it rained and rained and rained and just kept coming on in. So quite an interesting evening, but you can see really the South and especially the West Valley did get the bulk of the rainfall.
So tell me, just by
the court, the
Okay, I see.
proposed order.
Hold on, let me see. I'll look at it right now.
Okay.
Okay. It looks good.
I mean, if you want anything changed, we'll change it, but that's the
No,
one.
The only thing I'm gonna do is email it to the ASA assigned to the 2018 cases.
It should be the DC and Venzer handled it with me. I forget her
Okay,
name.
I'll CC the DC and Benzer.
Yeah.
By the time I get to Martin, I'm have to look at the news.
It's Jennifer Garcia.
Yeah.
And I don't think Judge Benzer's gonna have any issue with it.
This case has a long, sad,
I'm
boring
sure it
story.
does. I'm sure it-
Yeah. And so it took a while to get them up to speed on it. He was accidentally released by corrections the last time he was stabilized. And then he was on the street for a while where he promptly destabilized. And we have another similar scenario where somehow he was just allowed to leave the hospital. And
It specifically says to be returned to custody upon release.
yeah,
It'll be good.
yeah. I mean, they're not gonna let him, he'll be in custody in the hospital. I mean. So. Alrighty. So then I'll just wait for the judge to pop back on and I'll just let her know that we sent it.
What I would, you may want to ask her to sign it now. So
Yeah, that's what I want her. I want her to sign it now so that corrections will take a copy.
Get the ball rolling, I know.
Yeah.
Also, I see somebody, Mr. Marino. I'm gonna promote you to a panelist, like taking a gamble.
You know what you do?
It's being bombed all morning.
Officer on deck. You know, come by the gap.
All right, Mr. Marino, what do you have? How can I help you?
Hi, good morning. I'm not sure. I'm with Chad Piotrowski's firm. He
Okay,
asked me to log in for a case that might be on calendar that we just got retained on this morning.
give me the name.
Max Bastuardo.
What is it?
Last name is Bastuardo, B as in boy, Astuardo.
ARDO. What was the first name?
Max.
Max. Okay, let me check it out.
Well, Michael, I tried to show off your channel. I don't know what happened there as far as a freeze goes, though. Maybe it was your fault. Everything looks healthy on this end, so whatever the hiccup was there, that was fully on YouTube. Let's go spend a little more time with Judge Middleton.
This is file number 251009SM, People versus Patrick Kelly Burnett. Mr. Burnett, you're in the same boat as the last guy with the same charge. Do you have insurance on your vehicle now?
I do, Your Honor. I actually got it within an hour and a half of the stop in the impound. So it was insured before it was taken out of impound.
Oh, it's expensive with the impound.
Yeah, it's $250.
Who's your insurance carrier?
They are, I have the picture on my phone.
All right, why don't you show that to Mr. Stickley?
Oh, Hackenberg and Schreiber.
Yeah.
Out of Three Rivers.
All right.
I don't know why my fiance didn't suggest it sooner. She said, why don't I just add you to my insurance? That would have been nice to know a month ago. I thought it had only been 2 weeks when I'd gotten pulled over, not a.
Hackenberg and Schreiber is an old Three Rivers, but there's neither Mr. Hackenberg or Mr. Schreiber are alive anymore, but it's been there for 70 years or more. All right, you have a seat. I'm gonna have Mr. Stickley check with the prosecutor and see if they'll reduce this charge.
Okay, thank you.
So that's two. Several people that didn't show up. Clifton Davis. Good morning, sir. Are you Clifton Navarre Davis?
Neve.
I'm sorry.
You're fine.
You got charged with no valid operator's license again. Let's take a look at your ticket. For a guy from Niles, you sure end up getting tickets over here.
Yeah, I don't be over in Niles anymore. I haven't changed my address yet.
Now you live in Battle Creek?
Yeah.
Let's take a look at your ticket. It was Sturgis. You get all over the place at 11 o'clock in the morning on May 29th. Charged with driving without a valid license. Nothing more in there. Your driving record. Shows you're not licensed.
Yeah, I got my permit now.
All right, well, good. You also got a bunch of unpaid tickets here in St. Joe County. 2023, possession of marijuana under 21, you got $144. 2022, no proof of registration, $12. You got a no proof of insurance, which they reduced from the no insurance, $258. So you have a total of $414 of unpaid fines. I can make some of those go away with the jail. Maybe not.
I can pay those.
What's that?
I can pay those.
All right, so you have a permit now?
Yeah, I just gotta wait a couple more weeks to get my license.
All right. 7325. Do you have your permit with you?
Yes, sir.
You show it to Mr. Stickley. I think I'm gonna do the same thing I did with the other guy. I'm gonna adjourn your case about a month. See if you can pay your unpaid fines and get your license. Pay fine and costs and get license. I'm gonna continue this to go with August 7th to the other case. I'm gonna give you this. Couple things. Give you a notice for August 7th. Are you working somewhere?
Yes, sir.
Where are you working?
In Flexion Gate around Battle Creek.
What's it called?
Flexion Gate.
What do they do?
We make Ford parts.
Okay, are you missing work now?
No, I don't go till 2:30.
Thursday, August 7th. At 8:30. Bring proof of license. Pay tickets. All right, even if you don't have your full license by then, bring what you've got. And here's the information regarding the tickets. I want you to stop out and see the ladies out there regarding paying those tickets. All right, we'll take another crack at this on August 7th at 8:30.
Thank you.
$414. That'll help your cause. You're good to go. Stephanie Vine. Good morning. This is file number 251177. It's alleged that on or about June 21st, you assaulted Danica Struckman, a former resident of your household. That's commonly known as domestic violence or domestic assault. I got 4 people that got arrested last night for this. This would be your stepmother or your stepdaughter?
Stepdaughter.
All right. You live out in the subdivision out by the soccer fields?
Yes, sir.
Work at American Axle?
Yes, sir.
All right. I guess my inclination would be to either set a pretrial or get an attorney appointed.
It would be appropriate at this point, at least, Your Honor, to appoint counsel.
Are you missing work right now? Don't be upset. I'm gonna appoint a lawyer to help you with this. Now, let me talk about what the options are. One option, prosecutor could dismiss the case outright. They could reduce it to something like disturbing the peace. Or there's also a statute which allows the domestic violence cases to get deferred. I have a women's anger management program that I started when I was prosecutor more than 25 years ago. And that may be an option. So nothing terrible is going to happen here, but is there no contact provision?
I haven't seen her. I don't know where she is.
So you're not out of your own house?
No.
All right, very good. How do you know my old friend Steve?
That's my stepdad.
Your stepdad?
Yeah.
Stepdad, stepdaughter. Old friend as in 70. I went to school with his sister from kindergarten. He went to school with my sister from kindergarten.
He's old.
Okay.
Yeah, that means I'm old. All right, I'm gonna show a plea of not guilty. Appoint an attorney. Set attorney pretrial for 8/1. We're gonna be very busy that day, but at 8:30. What shift do you work at American Axle?
Second.
All right, well, you won't be missing work. Now, I think you're gonna follow up on this. Often I tell people this and their eyes glaze over. They're gonna take you out and give you some paperwork with your attorney's name and number on it. I want you to call the lawyer and make an appointment to discuss this with them. They'll get the police report, be in a position to discuss it with the prosecutor and see what the options are. So we'll appoint an attorney. You'll call them and make an appointment, discuss it with them prior to August 1st. There should be plenty of time to do that. So do you have any questions?
Yes, sir.
All right, you're good to go.
Thank you.
See you around.
All right, hopefully not.
No offense, but I hope not. All right, a number of other people have come in that aren't on the list. So right now I'm just gonna see who's here. Is Jorge Garcia Palmer here? Do you need an interpreter? All right. Terry Frost. Ricardo Hernandez. Ryan Swinehart. Jonathan Trahan. All right, are there some people whose name I didn't call? All right, and what's your name, ma'am? Yes, we met, and you had a pretrial. So did you have your pretrial already?
No.
Let me make sure I got this right. No, you're an arraignment. So let me get your file. I don't know where it is. What's your name, sir?
Stacy Osborne.
Did you have a pretrial yet?
I believe it was supposed to be an arraignment.
No, you've got a pretrial on a no ops charge. So you're in the right vicinity. I can't find Miss Tepper's file. I don't know if I had it and lost it or didn't have it, but I do not have the paperwork on Tricia Tepfer. It just says file opened. I'm not sure what that means. But while we're hunting that down, let's talk to the customers that are here. Ryan P. Swinehart.
Good morning, Your Honor.
Good morning, Mr. Swinehart. We actually got two cases this morning. The arraignment case is file number 251179. It's alleged that on June 21st of this year in 3 Rivers, she assaulted Giselle Gonzalez, someone you have a child in common with. That's commonly known as domestic violence or domestic assault. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You were arrested, you posted bond, and the arraignment was set for today.
If I could clarify, it wasn't truly
No, you don't want to get into that.
All right, well, yeah, Mr. Stickley is here. I'm not unwilling to hear what you have to say.
It was a water bottle.
Stop, but anything that you say now could theoretically be used against you. So his sage advice is just don't say anything till you get a lawyer and help you with this. So I'm going to show a plea of not guilty. Appoint an attorney. Set attorney pretrial for August 1st at 8:30. Question is whether I'm going to leave you in jail between now and August 1st.
Yes, sir.
You have $1,237 worth of unpaid fines and costs. You're on probation for impaired driving.
I'm not on probation, Your Honor.
Okay, the probation was completed. Tepfer. What?
I didn't see that file on.
I was never.
You're never up. Did you recently?
251178. Tricia Tepfer. It says file open, so I'm not sure what it
I
is.
think that was added and I didn't see it, so I will.
All right. There's a warrant out for your arrest in the impaired driving case.
In the what?
In the impaired driving case, you were supposed to do the victim impact panel. You never showed up for it. So I did a show cause to have you come in and find out why you didn't go to the victim impact panel.
Probably
You didn't show up for
because I was
that.
watching my kids, Your Honor. I'm a stay-at-home father every day.
So then I was gonna deal with this, but you already went to jail, so potentially I could give you the credit for the day you served. Stay-at-home father doesn't excuse you from your
Yeah, I
court
understand that.
obligations. We got a lot more stay-at-home mothers than we have stay-at-home dads. Sorry, I can't do my jail time. I'm a stay-at-home dad.
That's not
Sorry, I can't go to court-ordered victim impact panel. That ain't how it works. And you got all these other stuff that you aren't paying on. And now you've got a domestic assault. Is Giselle Gonzalez the mother of your children?
Yes, ma'am.
And right now you have a no contact provision?
No,
Now let's take
she's
a
at
look.
my house right now with both my kids.
The bond conditions.
Is that on the bond condition?
No
She's-
contact whatsoever with Giselle Gonzalez.
She's the one that bonded me out, Your Honor.
Well, maybe I'll just put you in jail, then we'll wait till August 1st. You're not supposed to have any contact with her. The magistrate told you that at the
I
time.
never
of your
talked to
arraignment.
nobody. Never talked to not a soul.
He might have just posted and got an interim bond, Your Honor. That's why he's here on a walk-in arraignment.
Never talked to nobody at all.
Did you talk to the magistrate over the video?
No, Your Honor, I did not. That's why I'm confused on the no contact.
Well, perhaps you're justified. Threw water in her face and acting crazy. Said she was intoxicated. She was wet, which could be an assault. They began to argue, threw water on her, called her names. You guys are too old for this.
Yes, Your Honor.
Came home late from work and drunk, so you got mad at her and threw water on her. All right. Appoint an attorney. This is not great. Also, I'm gonna recall the warrant in your probation case. Or, you know, in
If it's just
here.
an open case, it just probably needs to get a rain on it, or?
He failed to show up for the victim impact panel, so I tried to get him, they rescheduled, he didn't show up. I did a show cause to find out why he didn't show up, and he didn't show up for that, so I issued a warrant for him. Then he gets arrested for this foolishness. So I'm gonna set everything, set that also for 8/1/25/8/30. I'm gonna lift the no contact provision. It's sort of a farce the way it is right now.
Thank you, Your Honor.
Also, I can wipe out your fines. with
I
a
understand.
With a bunch of jail. So far, I don't know what to do with you. You don't pay the fine. You don't do the ordered victim impact panel. You got $1,200 worth of unpaid stuff. So if I just give you a fine, that doesn't have very much meaning.
That's off your docket. Jimmy took it off yesterday. Or you say,
Well, what is it?
it's a dismissal.
What was she's here.
You come in, I'll give her a copy of the dismissal.
What was the original charge?
I didn't notice what it was. Sorry.
Ms. Tepfer,
Yes,
whatever you were charged with, I can't even tell what it was.
I didn't know either. Actually, they didn't tell me nothing, just
It's been dismissed by the prosecutor. So if you go out to the counter, the ladies there will give you a copy of that order of dismissal right out there.
Thank you so much.
All right, Mr. Swinehart, you go out with the court officer. I want you to start paying on those fines and costs.
So I've put in multiple job applications since the last time we've talked.
Yes.
I've stopped. I haven't worked for my grandfather at all this year. I worked for him one day out the year. I did a couple wheel bearings. I haven't been able to work because I've been at home with my kids.
All right, well, let's find out what we're gonna do here.
It's been a little difficult right now.
All right. We'll get a lawyer to help you with it. I recall the warrant for your arrest. I've lifted the no contact provision because somehow it fell through
Thank
the
you.
cracks. I don't want to see you again until you're here.
I
with
don't
a
want to
lawyer.
see you in the
All right, you're good to go.
Thank you.
All right, real quick before we go over to our next court, I wanted to point out over at courtroomfiles.com, I do have a 4th of July special running at the moment, 15% off your entire order, and that runs through the end of Monday. There is a code in the banner at the top. It is TCF for USA. If you use that code at checkout, you get 15% off your entire order, whatever you want. We've got lots of great stuff over there, some new Ellie merch that we put up a few days ago. If you're a channel member, you save even more, as you probably already know. So if you do intend to purchase something and you want to save a little bit extra, make yourself a channel member first so you have access to that code, because that's certainly the way to do it. Let's go back to Judge Simpson.
Today is the date and time for a probable cause conference. I do have a green sheet filled out. We are just asking for an adjournment for plea negotiation purposes, if we could go about 2 weeks. And then, Your Honor, I would like to address a couple conditions of bond.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Yes, that's the bond.
So currently, Miss Black is on a GPS tracking tether, and there is also an order that she not go to her mother's house, but not in order that she not speak to her mother. Miss Black lives about a block away from her mom. It's my understanding there was an incident immediately preceding this one that is still being investigated, where Miss Black and her mother would be the alleged victims. From what I understand, Miss Black was ordered not to go back to her mother's place because another person involved may live in the area. However, Miss Black has 4 children. She's still living a block away from her mother's house, and it is just inconvenient that she can't go over there and drop her kids off, because her mom does help with childcare. And additionally, I feel that condition doesn't really relate to the charges in this case. So if you'd consider lifting that no-go to and removing her GPS tracking tether. And I don't believe there's any suggestion that Miss Black is a flight risk.
Response?
I would ask, at least for this, at this point, the remain is currently set. When the police had contact with Miss Black, it wasn't a call regarding potential FA, but she was highly intoxicated, really aggressive with police, ended up doing police car, was combative. I'm just concerned, whatever the heck is going on at that 407 address, I would hate for there to be any sort of bringing up whatever dispute led to the initial police contact that would cause Miss Black to have a negative impact on this case.
Motion for modification of bond, changing any conditions is denied. Bond will continue with its conditions.
Your Honor, if I could just clarify about the tether, I believe the tether is just tracking her. It's not an exclusion zone.
It's a location tracking tether.
Yes, so I'm not sure what purpose that.
So you want me to redo the ruling I just gave? Is that what you're asking? How many times have you been before me? Yeah.
Few.
How many times have I ever done that when I finally ruled?
Understood, Your Honor.
Never.
Understood.
So I don't know why you think I'd start today. So are we done?
Yep, we're done.
Okay, thank you. Court calls the case People versus Raymond Bowman.
Constable Bates on behalf of Mr. Bowman, Your Honor. Mr. Bowman, can you state your full name for the record?
My name is Raymond William Bowman.
I have before me a plea form. Is that what we're doing?
Yes, that's correct, Your Honor.
Plea form indicates that the defendant will plead count 2, possession of a weapon in a weapon-free school zone, 9 misdemeanor. And upon a successful plea to that charge, count 1 would be dismissed.
That's correct, Your Honor.
Is that a correct statement?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Raymond William Bowman.
Sir, it is this court's understanding that you are pleading no contest to the charge of possession of a weapon in a free school zone, in a weapon-free school zone. Is that correct?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand. The first thing about a no contest plea that you have to understand is that it means that you are not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
You're under potential civil liability.
And understanding all of that, sir, you still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
I understand, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am on probation in Wayne County.
Were you on probation at the time of this offense?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 4613-20. Any objection to the court having reviewed that report?
No, Your Honor.
No objections, Your Honor.
Counsel, there is not an indication of a school, the zone.
It would just be to the higher, Your Honor.
So accepting the higher,
There's no good misdemeanor for a firearm.
so in looking at that, then, all right. Sir, if I do accept your plea, I have to have you understand that any sentence evaluation, if there were any or any recommendation, the court would not be bound by if you committed any misconduct as defined in the Michigan court rules. You understand that?
Yes, Your Honor. I
You
do.
also understand that you would not be entitled to withdraw your plea.
Yes, I understand.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied, Your Honor.
And based upon the police report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. The court will accept the defendant's plea to no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
July 9th, 2025.
July 9th, 2025, 9 a.m. That's before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, my client is asking to be released on a PI while he waits his sentencing. My client is unfortunately very ill. He needs to go back to the hospital. He's actually due to have a procedure done today, correct, at 3 p.m. It's quite an intense procedure. He's also going to be
Is this the only thing holding him?
in here. Yes.
Judge, he has-
What do you mean here? Yes.
He has a hold out of Wayne for the DUI. He has bench warranted 4 times in this case already, so people think he should be held until a receipt by probation.
The bench warrant, I believe, was due to him being hospitalized, and that's why he failed to appear previously.
What about the bench warrants in?
I'm to be released to treatment from Wayne County. That's why, my sentencing, would need to be, I'm going to the Salvation Army. And I need it set up on Zoom. So if, you were to release me, I would go to Wayne County Jail and wait for treatment to pick me up. And then I would be at the Salvation Army there.
Anything else?
Nothing further, Your Honor.
I don't think it's appropriate given the defendant's track record in this case and the very fact that he has another hold to release the defendant. Therefore, the motion for bond reduction in this case at this time is denied. I'll be seeing him next week. So
understood, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls case of the People versus George Bowman.
Zachary, the word on behalf of the people.
That's the public defender, Nicholas Buckovich, on behalf of Mr. Bowman, who is now approaching. May you please state your name for the record?
George Bowman.
Go ahead.
At this time, Your Honor, be setting this matter for preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 15th. What is that?
Right.
Yeah, I do feel threatened, but Alan doesn't. What is that? We don't know. Have we ever figured out what it is? That happened to me?
Every morning.
No, I'll be good. Don't worry about it. No, I'm all right, man. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Washington.
He'll be here. Yep.
Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Troy Brumfield.
Your Honor, Alexis Plumai appearing with and on behalf of Mr. Brumfield. And Mr. Brumfield, could you state your full name?
Troy Brumfield.
And Your Honor, I do have a green sheet here. I am asking for an adjournment. I was not aware that Mr. Brumfield was in custody until this morning, so I would need some time to go over discovery with him. And I would again like to address.
And you're also, you want to address this bond? Have
would.
you seen the new complaint for conditional bond violation?
I have.
Okay, go ahead.
Your Honor, Mr. Brumfield was just arraigned last week. I do understand that there were 2 violation reports filed, one for a failure to test on the SoberLink device that was ordered, and the other for a new complaint with the allegation that Mr. Brumfield allegedly took some food from the University of Michigan Hospital. I would still ask Your Honor to consider a personal recognizance bond here with a scram tether rather than a SoberLink. I think that might be easier for Mr. Brumfield to test. And it's my understanding that
Are there new charges that are going to be coming from that?
Your Honor, that is just new. We have not received a new warrant request yet.
Got it.
Receiving it shortly.
Yes, and it's my understanding that he's not being held on anything to do with the new report.
Any response from the people?
Your Honor, we would reject the defendant's release at this time, considering the 2 separate bond violations with the criminal history that does include the fraud and his prior orderly DUIs. If you were considering his release, we would ask for that scram tether, considering that he did not test at all on his sober.
That's part of the problem. He didn't test. And that is allegedly out there, at least, or places himself in a position where he's committed another offense.
I understand, Your Honor, and I think the scram tether would solve that testing issue, and I would just emphasize that it was just a few days that he was not testing. I did attempt to reach out to him when I found out, but I believe we just didn't have updated contact information for him. Would still ask the court to consider a personal bond and a scram.
Motion for bond reduction is denied. Probable cause conference is adjourned to July 17th, 2025, 9 a.m. Bond will continue as denied at this point. She's sloughing off. Court does call the case. The people of the state of Michigan versus Grace Brenner.
Good morning, Your Honor. Assistant Public Defender.
Assistant Public Defender Hannah Apple, appearing on behalf of Ms. Brenner. Your Honor, can we approach?
I didn't know. You just started walking up. I told you I feel unsafe.
All right, well, they do their little sidebar. Let's go back to Fulton County.
Sorry, Your Honor, we didn't have an announcement for this one. Is this Miss McLeod's case?
Yes, I thought there was an announcement. There was a.
Is it a negotiated plea?
It's not going to be a negotiated plea, but there was an offer here. That I'm seeing. I discussed with my client and he's not interested in it, but you know, it is here.
Yes, Ms. McLeod. I think what ASG Harrison is trying to say is that she understands she submitted an offer. We just didn't know whether the offer was, whether you were taking the offer as a negotiated plea, a non-negotiated plea, how you were planning to proceed with this case.
Oh, yes, Mr. Welch is a negotiated plea. Okay, Mr. Welch is a negotiated plea, yes.
Right.
Okay, thank you. Your Honor, the state's recommendation for count 1 battery is 12 months served, 32 days, credit for time served, 14 days, balance suspended, no further violent contact with Rodney Giddens. Count 2 simple battery will merge with count 1. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. And that'll be all for this.
Stipulate.
Thank you.
All right, Mr. Welch, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
And I'm going to ask you a series of questions to make sure that you understand the plea that you're taking today, okay? And that you understand the conditions. All right, are you presently under the influence of any medication, drugs, or alcohol at this time that would impair your understanding?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you'd receive a lesser sentence for pleading guilty?
No, ma'am.
And do you understand that if you're currently on probation, it could be affected or revoked because of the guilty plea?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, I will accept your guilty plea. And you understand the conditions, is that correct?
Yes, ma'am.
All right, so balance suspended, no further contact with Rodney Giddens.
Yes, Your Honor, that is our understanding of the plea.
Okay. All right, I will accept that plea. Thank you.
Your Honor, I also have, Mr. Porter,
He's on his way up, 36 and 37.
and
Okay.
I have as well Mr. Mason. And Mr. Mason is going to be a plea.
Okay. So 36 is Timothy Porter, 25 CR 003238A. And 37 is 25 CR 003242A. We'll start with position 36, one count of criminal trespass and damage to property. State?
Yes, Your Honor. Count one, criminal trespass and damage to property. State's recommendation is 12 months, served 44 days, credit for time served 22 days. The balance will be probated. No further contact with Cedric Holmes. Stay away from 1053 Cascade Road, completion of an alcohol awareness course, 20 hours of community service, and $800 restitution to Mr. Cedric Holmes. For position 37, the state's recommendation is in count one, simple battery, 12 months, served 44 days, credit for time served 22 days, 40 hours of balance probated, 40 hours of community service, no further contact with Danny Porter, stay away from 1751 Cascade Terrace Southwest, and no firearms. The defendant also has another case. The case number is 24CR000297A. It's a criminal trespass case. The state will no pros that case upon the plea to the other two positions, Your Honor. We ask that the defendant stipulate to venue, facts, and ID for purposes of the plea. And we'd also like to sound for the victim, Your Honor, Mr.
Your
Danny
Honor, this is
Porter.
not going to be a plea. Mr. Porter is not going to accept the state's plea offer.
Oh, I'm sorry, Your Honor. I misunderstood. I
Yes.
thought this was a plea.
No, my other case, Mr. Mason is a plea, but this
Oh,
is
I
not.
thought Porter was a plea.
No,
No?
Your Honor, Mr. Porter is
Okay.
not going to plea.
All right. Does he need to be arraigned?
I filed an arraignment for him, Your Honor. He just needs to be put on the next available trial calendar for court.
Okay.
Okay, perfect. Thank you, Ms. McLeod.
You're welcome, but Mr. Mason will be a plea.
Okay.
32 and 33, Mason.
All right. This is 23 CR 007020A, Octavius Mason, and then the 25 FTA 001238. Go ahead,
Yes, Your,
State.
yes, Your Honor. For position 32, the simple battery, state's recommendation is 12 months, served 30 days, credit for time served 15 days, balance suspended, no further contact with Muhammad Guy. And for position 33, the state will null pros the failure to appear upon the plea of the underlying charge. We ask that the defendant stipulates a venue, ID, and facts of the case for purposes of the plea. And that'll be all for the
So
state.
stipulate.
All right. And so, Mr. Mason,
Yes, ma'am.
I understand you wish to plead guilty today to one count of simple battery. Is that correct?
Yes, ma'am.
All right. I have a few questions I need to ask you, okay?
Yes, ma'am.
First, are you under the influence of any unprescribed medication, drugs, or alcohol that would impair or hinder your understanding today?
No, ma'am.
All right. And are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty today, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you agree to waive these rights today, correct?
Yes, ma'am.
Has anyone told you you receive a lesser sentence for pleading guilty?
No, ma'am.
All right, and has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected or revoked due to this guilty plea?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with a full understanding of the charge against you?
Yes, ma'am.
All right, I will accept your guilty plea. You have no further contact with Mohammed Giaye, I believe is the last name. All right.
Yes, ma'am.
All right. Thank you.
Number
Your
30,
Honor, I do have another client, but I understand that he's not available due to some MH issues. It's Mr.
Okay.
Peters in position 35. I have not been able to speak with him.
Okay.
But that would be all my cases, Your Honor, and I do have an appearance before Judge Roth. So I am asking the court's permission to log off and take care of that, and then I will come back to see if Mr. Peters is available.
Okay. All right. Thank you.
Thank you, Your Honor.
Uh-huh.
number 34,
Okay, Mr. Perez, 25 CR 0000245F, Santos Perez, charged with request for ambulance service when not reasonably needed. Is that the charge?
Yes, Judge.
I'm sorry, before we proceed, it looks like on our end, Mr. Perez has two cases, but both cases are not on the calendar. Are we handling both cases today?
We are, it's in the notes, Judge. The other case is listed as well in the solicitor's recommendation. So we're trying to resolve both cases, Judge. This would be a negotiated plea, except, Judge, I'm asking if we can change the fine to community service or suspend the fine.
Okay. ASG Harrison?
Yes, Your Honor.
There was a question. They want to convert the fine, is it $300 fine to community service or suspend? What does the state say about that?
The state will leave it in the judge's discretion. I believe that one. I'll just check to make sure, but I believe that might have been a statutory requirement.
This Judge, I do believe the
It
court has
is.
discretion.
Yeah, so we'll have to leave it to the court's discretion, Your Honor, but we do have to recommend it.
All right, I will convert it to 30 hours of community service.
Thank you, Judge.
All right, you ready to take your plea, Mr. Perez?
Yes.
All right, I'm going to ask you a series of questions to make sure that your plea is free and voluntary and that you understand what you're doing this morning. The first question is, are you under the influence of any unprescribed medication, alcohol, or drugs at this time that would impair your understanding?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
And do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you agree to waive these rights today, is that correct?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you do understand that if you're on probation, it could be affected or revoked by this plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right. And you understand your conditions as well, correct? All right. I will accept your guilty plea.
Thank you, Judge.
Okay.
And Your Honor, if I may briefly, we didn't actually read his recommendation out. I'd just like to
Oh,
read
I'm
it out for
sorry.
the
Go
record.
ahead.
Yes, count one will be 12 months probation, serve 22 days, credit for time served 11 days. The balance will be suspended. This is a global recommendation with an add-on case number 23CR003236F. The charges are pedestrian in the roadway, pedestrian under the influence, and obstruction. Count one, there will be 12 months probation concurrent with case number 25CR00254245F. Completion of an ADET. Count two will merge with count one. Count three will be 12 months probation concurrent with count one. Completion of 40 hours community service. And Your Honor, you waive the fine. And we just ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea.
And we stipulate, Judge. Thank you.
All right. Thank you.
And Your Honor, before we start with ACDC, if I can have them call courtroom 2, I just need to speak very briefly with all three defendants, Judge.
Okay.
I'll go ahead and give you a call now. Good morning.
All right, thank you. Thank
Number 12.
Good morning, Judge. This is Mr. Cowart. We're asking for a bond hearing.
All right. And Mr. Coward, this is case number 23CR006545J. Being charged of 1 count of theft by conversion. And state.
Yes, Your Honor, if I may just have a moment.
Okay.
Doing a little bit of multitasking on my end.
I
Let's see.
understand.
We are.
And can pretrial services read out his history for the judge?
Just a second. I'm trying to find Coward.
Okay.
Brenton Coward. Oops. I lost it. Hold on a second.
Thank you.
Okay, so it's Your Honor, this is an FTA on this case. He currently has a $7,000 surety bond on the FTA. Previous to that, he was given a 3,500 signature bond by Judge Lull on October 21st of 2023. In this case, Your Honor, it's alleged that on October, and this was a private warrant taken out, it was alleged on March 9th of 2023, the defendant rented a vehicle and failed to return the vehicle. And as of March 13th of 2023, had still not returned the vehicle. This was to the company Sixt Rental Cars. And so that is the basis of the theft by conversion. As far as his history, the defendant, if I may, I know pretrial is still looking for it, but I have his history if Your Honor would like me to read it out.
Okay, that'll be fine.
The defendant has 24 cycles, including this case. He has an FTA. His most recent is an August 2023 FTA from Douglas County. Prior to that, he was arrested in Banks County for DUI, possession of methamphetamine with intent to distribute, giving false name, and that has no disposition at this time. We also have a arrest for possession of methamphetamine with intent to distribute in 2022. August of 2021. That also has no disposition. That was out of Athens, Clark County. We have a probation violation in 2021 where he was revoked to the Madison County Jail for 12 months. Then we have a probation violation from 2020 out of Madison County, a DUI from 2017 out of Madison County, which he received 12 months and a $600 fine. That was also included with a possession of methamphetamine, where he received 3 years probation, and a probation violation in 2016 in Madison County. That case, his balance was revoked to state prison and he was required to attend RSAT. That was based on a 2017 conviction for possession of methamphetamine and possession of drug-related objects. So those are his cases in the last 10 years. He also has an FTA from 2015 as well out of Madison County. So, Your Honor, the state would ask that the bond remain as set. The defendant has, as you heard, at least 2 FTAs, multiple probation violations that resulted in prison or jail time, as well as a number of drug charges. We believe he is likely to not appear for court should he be called, especially considering this would be his 3rd FTA since he failed to appear on this case. And we have concerns about his risk of reoffense. That's all for the state.
All right. Attorney White?
Your Honor, this FTA and at least one of the others are due to incarceration. He was actually in Gwinnett County, and I can forward that to the state, for about 8 months, and then released directly to RSAT, and then transferred after completion of that to here. So he's been incarcerated continually for about a year now. And additionally, he has completed a residential substance abuse treatment program, which is the basis of 99% of his problems. So we believe he was incarcerated either at RSAT or Gwinnett County at the time he missed this. Additionally, the case is a theft by conversion, which was an argument with a rental company. We think this is more appropriate in civil court. They are welcome to sue him. I believe they eventually did get the rental car back. So we're asking that he be able to sign his own bond at this point. So we do have proof of incarceration in Gwinnett County. I can get those dates at some point, but then he informs me that they transferred him to the RSAT, which you heard the state say that he was ordered to do, and then transferred directly from there to Fulton County Jail. So he hasn't been out of jail for over a year at this point.
And Your Honor, normally we just receive the dates of incarceration and we are able to consent once we have proof of the dates of incarceration. So if Your Honor would like to move on from this case, giving PD White a chance to send me Your Honor, the dates of incarceration, I think that could be resolved.
Okay.
And Judge, we are having trouble confirming the RSAT. I believe what he tells me, he has been in jail. When we do have the Gwinnett County portion of that, we do have that proof. But the Coastal State Prison Gateway services thing, we're not able to contact people that can confirm that at this point. I've had an investigator looking at it for he's been reset a couple times to try to find this information. I did leave a message with his sister as well yesterday. She can confirm that, but I have not been able, haven't heard back. But given the age of the case, the length of time that he's already been in jail at this point, the fact that he is now clean and sober and has been for some time, we don't foresee an issue of him missing court again. We'd ask that you give him the signature bond. And we will continue to follow up.
State, I do understand normally we have those certifications or we know those dates of incarceration.
And Your Honor, I would say not normally, always. That's something that our office has long.
There's nothing.
If I may finish, that is something that our office has always requested of the PD or any other, or any defense attorney if they are arguing that the defendant was in continuous incarceration.
And Judge, I understand the state's position, and obviously we're trying to get that information, but the totality of the circumstances, we don't feel he should be held, even if he wasn't. If we can't come up with that actual documentation, we're certain that he has been incarcerated for this amount of time. And given the charge, the age of the charge, the amount of time that he's been in jail, the state has offered him a time served offer as well, if he were to say guilty today, with some probation. But with all of those considerations, we just ask him to give him a signature bond and give him one more chance to come to court.
I'm not inclined to give him another signature bond today. If pretrial can assist in getting that information, or you can get it before the end of the calendar.
Okay, Judge, we will, I don't know if pretrial can confirm that or not. If they can, that would be amazing. We'd ask to reset him to next Tuesday, and we will continue to work on it. We don't want to keep him here any longer than we have to. So
I understand. We just need to have the documentation. Pretrial, have you found his history yet at all?
Yes, Judge, I did. Y'all wanted to see if he's been in custody. I see where he's been incarcerated, but on his GCIC, it won't say whether or not he's in custody. I will have to research it just like Mr. White is doing, and I won't be able to tell directly whether or not he's been in custody, but I can see where just before the FTAs, he has been arrested. Like just before the FTA, he was incarcerated in Bank 6/8/23, and then the FTA will be 8/9/23. So it could be lead to reason that he could have been in custody, but just before the FTA.
Mm-hmm.
Makes
The
sense.
FTA was issued in January of 2024.
No, I'm talking the other FTAs you mentioned, Ms. Fogg.
Understood.
So, that are on his GCIC. So just before the GCIC, she mentioned on his GCIC, he was incarcerated before those FTAs popped up. And where he's saying he's been in continuous custody, I see where he was arrested in Athens. Not Athens. The most recent was in Banks from 6/8/2023 for a misdemeanor. And generally, if he's been in custody, it will say he got some time on something, but it doesn't show where he was sentenced. And that generally is where I would infer that he was in custody, but I don't see anything where he was sentenced on anything to say he was in custody.
All right, state.
Same announcement as before. I think Mr. PD White is absolutely accurate in the assessment that we may need to continue this until Tuesday to give them further opportunity to research the issue and come up with proof of incarceration.
Okay. All right, we'll reset it to Tuesday for you all to come up with the documentation, Mr. White.
Thank you, Your Honor.
All right, thank you.
Section 49 and 50.
So I want to show you this still. This is from the 13th judicial in Kansas. This is Judge Hart's court, where apparently defendants who are waiting are now required to be held inside a shipping container. So it's a sad, sad state of affairs in the 13th District of Kansas. Let's do this. Let's go back to Judge Simpson for just a little bit.
Which case is he on?
In the case 0907, he has indicated to me that he cannot currently post that bond. In case 0889, he currently has he was granted a personal reconnaissance bond, so I'll just be asking for a nominal cash bond to allow him to get credit for time served in both matters. I would also be asking for a release to treatment in both cases, and I understand the court would like an order filed with that.
Just filed an order to step out or release anybody to treatment if that's what they want. I'm not gonna have a problem with that unless there's some objection. Just get a stipulation to do that.
Yep, and I will get that to the court as soon as possible, Your Honor.
All right, so I will adjourn the matter to the I'll adjourn this matter to July 17th, 2025, 9 a.m. With reference to his bond in case 09 or 0889, I will reset his bond to a $1,000, 10% off. All right, so that he receives credit. He'll have to. Thank you. Court does call the case People versus Sean Cotton.
Okay, Richard McDuffie for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cotton, who should be appearing via Zoom.
Mr. Cotton, please state your name.
John Cotton.
Your Honor, at this time, we'll be requesting an adjournment to for the client to pay some restitutions toward his offer.
PCC will be adjourned July 17th, 2025, 9 a.m. Bond continues. Court does call the case of People versus Chad Jones.
State your name for the record.
Chad Jones.
Your Honor, we are requesting a brief 1-week adjournment for a global resolution. The prosecutor needs 1 more week to get in contact with 1 witness. So we have 2 on board. They just need 1 more.
Some green sheet.
Yeah.
You're going to be able to get it all accomplished in 1 week, so I'm not going to be back here and then ask you for another week.
Yes, Your Honor, everything is set except for one thing, and once that's addressed, it's be set.
Probable cause conference will be adjourned to July 10th, 2025 on all 4 cases, or 3 cases. 9 a.m. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Donovan Dronkowski.
Okay, Richard McDuffie for the people.
Also, basically on behalf of Mr. Dronkowski, but not with him, Your Honor. Unfortunately, I've not had contact with my client. I'm unsure of his whereabouts at this time.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately.
Your Honor.
Court does call the case People versus Daniel Franklin.
Andrew Field is appearing on behalf of the people, Your Honor.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Franklin.
Your name, sir?
Daniel Franklin.
Thank you. All right, what are we doing on this case?
I spoke with Mr. Johnson. I don't know what has been, so I believe he has been tendered discovery, and I think we're just looking to set this matter for an examination.
Is that a correct statement, Mr. Johnson? You'd like this matter set for prelim?
Yes, Your Honor, and we're asking that the prelim be set out a ways. I believe the people will be calling a cooperating witness who is in federal custody. Because of the likelihood that this witness may become unavailable down the road, I will be asking for the people to present any and all information they have relevant to cross-examination under US v. Giglio. And I think the people may need some time to get that. And I don't know if the people are even in possession of the federal indictment in which this witness is cooperating under and giving this testimony, but I would like to have that before exam as well.
Your Honor, I have no problem with that. I have no problem with setting this matter out. As the court may remember, Mr. Franklin is being held on another homicide case that is pending before Judge Conlon with a trial date well into the fall. The reason.
So why am I setting it for exam if everything's not ready?
This cooperating witness is currently being held at FCI Milan. The moment we have an examination date, I can give a writ to them. They won't transport him. Otherwise, it sounds like he's going to eventually go to West Virginia, and I'd like to have that writ before the Bureau of Prisons transports him out of the state. So the date,
especially to West Virginia, because people don't come back. No, I'm kidding. I love West Virginia.
I don't know.
Okay.
And so that would be the reason I know. And as I spoke, Mr. Johnson and I spoke yesterday, and I believe we're on the same page.
All right. So how to get accomplished everything? How much time are you guys looking at? I get why you want a date out. I'll set the exam, but
perhaps I don't know what the court's availability is. I'm looking into kind of August.
Mid-August. I can do August 12. I can give you a prelim date on August 12.
That works for the people. That works for Mr. Johnson.
Your Honor, on August 12th, I have another homicide exam in the Lansing District Court.
Gotcha. Well, that's my only set PE date in that date. Did you want me to kind of give you a Monday and that way more flexibility to do that?
August 11th, if the court is available that day, that would be perfect for me, Your Honor.
Monday would be fine, and just for the court scheduling purposes, I wouldn't expect this to be something that would take more than half a day. So
okay.
That'll be a full day examination.
That's okay. So what I'll do is I'll just put it on my docket. I should have asked, do I have the 11th available? And if we don't pick a jury selection in the morning, so I can set it in the afternoon. Oh, I did set an order here. Okay. Pardon? I can do Monday the 18th. Will that work for you, Mr. Johnson?
I'll be in a jury trial in the Washtenaw County Circuit Court on the 18th, Your Honor.
No way. No, I'm kidding.
The 25th works for me if that works for the court.
No, because I'm gone. Right. Well, August, I know it's going the other direction, but would August 4th work?
I think August, at least from the people's perspective of getting the information, Mr. Johnson, August 4th would work for us.
Mr. Johnson, August 4th work?
I will be in trial August 4th, Your Honor.
The whole day?
Yes, Your Honor.
All right, give him a Tuesday. I don't know what Johnson's schedule is. I don't know why I'm setting around Johnson anyway.
My other thought is if we could set it on a Tuesday, perhaps the 12th, knowing that we would then get closer to the date and perhaps talk with the court about a skip to move it. As long as I have the date to hold this witness, I don't care if we move it. I can send it.
Why don't I do this then? And then this way you can kind of figure it out, and then we can move it to give you more flexibility in terms of dates, because then we'll be able to figure out my dates a little bit. I'm going to set it on July 22nd. Okay. With the understanding that you guys may have to move it, but then we'll move it on my docket.
That's fine.
Okay.
Yes, Your Honor.
So preliminary examination in person will be set July 22nd, 2025 That's at 12 noon. So that's an afternoon prelim docket or PE docket for me. All right.
Thank you,
Thank you, Your
Honor.
Honor.
All right.
Mr. Johnson, I'll contact you early next week and we can go over
Yes, sir.
everything, okay?
All right. Thank you, Mr. Johnson.
All right, so Thursday this week is the new Friday, which means it's time to change things up as we're only about 45 minutes from ending our day. So, da 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 dungeon court.
Stephanie Goff, 22-1061. Stephanie?
Yes.
Okay.
I'm short, I ain't that short.
I just wasn't sure. Okay, so you're making payments on your funds. So
I turned in the community service thing, I just now started.
She turned in 2 hours today, Your Honor.
That's all I have right now, but I should be able to get it finished in the month.
Mondays or Fridays for your hearings.
It don't even matter.
Okay.
The
We'll
furthest
set it
one out.
August 15th.
When?
August 15th.
All right, thank you.
Get it finished, you don't have to show up. 9 o'clock, August 15th.
All right.
James Conley, 22-2720. Okay, the only thing you have to do is the dip score, I believe. Is that right?
You told me that if I completed the treatment that I was in, that I didn't have to do that last time I was here.
Your Honor, I saw that in the computer, that is correct.
Okay. Do you have a report on your treatment?
He's not here today, I guess.
Where are you going?
TCC.
Okay. Are you still going there or are you finished?
I finished the Hughes reentry, but I went to transitional.
Okay, so you're still there? You're still in transitional?
Yeah.
Okay. Are you working?
No, not yet.
Okay, so it doesn't matter what day. I'll set it for August the 11th, that's a Monday. 8/11, 9 o'clock. Bring the report, usually Ron Turbin is here from the counseling center, he can give you a report, but he's not here today. Okay, 9 o'clock, August the 11th.
All right, thank you, Your Honor.
You're welcome. Jennifer Cooper, 23/11/27. Has done dip school and completed community service. Is it RRS? Okay, it's a good report. And you're gonna work off your funds?
Yeah, I have been.
Okay.
I only got a few more days to go.
That's fine. I'll set you for August the 18th. That's a Monday. August the 18th. 9 o'clock.
Thank you.
You're welcome. Brian Crawford. 24/3/30.
He left it.
All right, Mr. Crawford, are you anything on your funds today?
No. Yes.
Okay.
I already attempted to give him a drug screen this morning. He was unable to do it. Although I do believe he may be under the influence at this time.
Okay.
We met a few days ago.
He did admit that he had used after he left.
Yeah.
I haven't been to OVP. They said that if I come to court, they'd take me directly afterwards because I had scabies there for a while and I was contagious and they wouldn't accept me.
Is there anybody here?
I have not seen anybody from OVP.
Your Honor, I'm online.
Okay.
Mr. Crawford did complete an assessment with us on the 26th, but then he never reported for treatment. I'm sure we would be willing to take him if he's willing to come into treatment though.
Yes, ma'am.
Can somebody pick him up here today or?
Let me see if we have a bed for him, since we have not heard from him. Let me make sure we have a spot for him, and then I can let you know directly.
Okay, well, I'm gonna place him in custody until that happens, so.
Right back this way.
Robert Hamlin, 19/9/16 anything on your fines today?
Tuesday, this coming Tuesday. I made a payment a few weeks back.
Yeah, let's see. June 20th, you did, okay. I'll set your next hearing for August 1st,
All right, thank you.
9 o'clock, August 1st. Gary Kazee. Gary Kazee is 16-166, 14-309. He still has things left to do and hasn't appeared, so there'll be a warrant for failure. Donald Sharp.
Yes, sir.
Donald Sharp is 08-1591, 09-650, 14-263. Still have 2 days of community service left to do. And fines to pay. Have you done anything since your last hearing, Mr. Sharp?
Last time that I seen you, sir, I got these today, and now I'm at the Hub Source Treatment Center.
Where's that located?
Up in Portsmouth, Ohio, 1139 17th Street.
Okay, is there somebody there that can confirm that? You got somebody in the room with you from Hope?
Yes, sir, I have the coordinator with me.
Okay, let's have it on now. All right, sir, can you identify yourself, please?
I'm Joe Harris.
And what's your position with Hub Source?
I'm the housing coordinator.
All right, you're confirming Donald Sharp is inpatient with you?
I am.
All right, I'm going to set his next hearing for August the 1st. As long as he's compliant, he can continue to appear by teleconference.
Okay.
August 1st, 9 o'clock.
Thank you, Your Honor.
You're welcome. Alexis Smith, 193668. She's at Southern Hope. Says she's compliant. You had children inside of town?
Yeah, I have one daughter.
Is there a children's services case open on that, or?
It was closed until I did parenting classes and things, and that's one of the things that TCC offers is the parenting classes for me to reopen the case.
Okay. Were you aware of her request?
Not until just now when she handed me that letter and I told her that she was more than welcome to give it to you.
Okay. Well, usually we have somebody here from the counseling center, but today, oh, we do. Mr. Tarvin is here. So I'm going to let you talk with him. I didn't know you would be here today. So this is Alexis Smith. She's at Southern Hope. She's from Scioto County. She has a child there. She's interested in stepping stones as a way of reunifying with her child. So why don't you all talk, and then we'll come back and decide how we're going to go forward.
Thank you, Ron.
Thank you.
Ron Wiggle, 164698, 14844, 13151. He's at RRS. Good screen. And good report overall. So he's inpatient now, right?
Correct.
Okay. All right, we won't worry about your fines or anything until all that gets further down the road. So we'll have you come back, August 8th. August 8th, that's a Friday. Be your next hearing.
Thank you, Al.
Good start.
Thank you.
Is that? Okay. That finishes the reviews, or how many arrangements do we have?
Two for here, and then we're ready to go to jail.
Okay, all right, we got two arraignments here, so I'll explain the rights. You were here, there was a video play, we'll go over it again. You have a right to remain silent, you don't have to say anything, but what you do say is all being recorded, so if you admit something about your case, that could be used against you later. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove any charge beyond a reasonable doubt. All defendants have those rights. You waive those rights by entering guilty or no contest pleas. Don't enter those pleas if you don't understand what's happening, if you're confused, if you don't know what to do, if you want a trial, if you want a lawyer to talk to, enter a not guilty plea when you're asked for a plea. That's always the safest plea you can enter. Call the first case.
State of Ohio versus James McClellan, case number TRD 21682, TRD 181168, TRD 163521, A and B.
All right, and Mr. McClellan's in treatment.
Yes, sir. He's currently in Shawnee Counseling Center in Portsmouth.
Okay, and you got a report to that effect? She's been there less than a month.
Yeah.
And did you self-report to Shawnee, or was that?
I did. I was going to Mahajans before that, sir.
Okay. All right. I'll agree with your going to Shawnee, and he's inpatient.
Thank you.
Yes, sir.
Okay. Well, we'll put on hold. You got community service and fines and costs today, but we can.
They said they'd work with me up there to pay off.
We got a program at Shawnee that lets them do the community service and send it to whatever county they are.
Okay. We need to discuss it with Mr. Cooper. I'll give you another review hearing in about a month. We'll make it August the 8th. Will be your next hearing.
Thank you.
At 9 o'clock. August 8th, 9 o'clock is his next hearing.
Thank you, sir.
Cancel any warrant that has been issued.
Thanks.
You're welcome.
Thanks, Sean.
You're welcome.
State of Ohio versus Alec K. Douglas, case number CRA 25263, CRA 25264.
May I approach your honor?
Yeah.
My name is Alec K., one word, A-L-O-I-K-Y, one of them is wrong.
Okay. All right, I'm familiar with Ms. Douglas, I know that's her. All right, you've got two charges. 25263 is the most serious, it's possession, aggravated possession of drugs. Alleged on March 31st of 2025, you knowingly were in possession of methamphetamine, which is a Schedule II substance. That's a felony of the 5th degree, maximum penalty, a year in jail, $2,500 fine. 25264 is a possession of drug paraphernalia charge. That's alleged the same date and time you were in possession of a glass pipe with residue. That's a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. And she came to Southern Hope when? When did you start there?
I was in Lawrence County Recovery. The 4th of April was when I went, and then about 4 weeks ago, I changed to Southern Hope.
Okay. And you just came in because you knew these charges were pending?
No, I didn't know that until a
Our
couple
court
days.
liaison looked at some things and realized that those were pending. At first, we couldn't find them because of the misspelling of a name, and then she was more than willing to address.
Yeah, her name should be all one word, Allykay.
Yes.
One word. Motion to amend.
Yes, Your Honor.
Okay, so amend the complaint. Okay. You haven't made hire a lawyer?
No.
And is anybody here?
Mr. Morford said he would be here at around 10.
No one's here yet. Your Honor, Roger Smith did tell me he'd be here Monday.
Okay. Well, I'll appoint you a lawyer. I'm just going to allow you to stay at Southern Hope, and we'll set a hearing for you. Let's make it next Friday. Monday's way overcrowded. So let's do the 11th, July the 11th. I'm going to appoint Stratton, because I think he'll be here then. I'm not sure about Roger Smith. So we'll let you sign a $2,000 signature bond with the condition further if you stay in treatment. And then bring her back to court a week from tomorrow on the 11th.
Yes, Your Honor.
Okay.
Your Honor, does she need to be fingerprinted?
She does. We'll work that out at some point. She'll have to go to the jail.
Okay. When would you like us to do that?
Whenever you can. She'll need to take that form, the bond form, with her to give to the jail personnel. So.
I'll bring you a copy of this.
Okay, next hearing, July the 11th.
Thank you, Your Honor.
Thank you.
You're welcome.
Your Honor, I didn't have a card for Mr. Stratton either.
Okay.
Next week. Next week's. You want to do that? She's out of jail.
I think it's one word. Oh, I see. Okay.
Okay, I notified Mr. Stratton.
Your Honor, ready to go to the Lawrence County Jail.
Okay, we have some hearings to do at the jail.
State of Ohio versus David L. Fetty, case number CRP 24-140, TRD 23-1820, A and B. And Derek Jenkins is on deck.
All right, Mr. Fetty, it's alleged that you missed a review hearing
Yes, sir, I forgot about it. I got seizures and stuff, and I didn't write it down, and I just forgot about it.
Okay. Where are you living now?
I stay with my sister,
Where she live?
by the park in Burlington.
Okay, so you're not that far away. How
No,
long,
sir,
how long have you been in jail?
they arrested me Monday.
Okay. All right, well, I'm going to send you anything else you want to tell me. You've got fines and costs to pay on 2 cases. And I'm going to give you...
If I get out today, I can go to the bank and pay.
Okay. I'm going to give you another hearing date. We'll make it easy to remember. It's going to be on August the 1st.
Yes, sir. Okay.
I'll send you your time served for contempt for not coming to your last hearing. If you pay it all off, you don't have to come to the next hearing, August 1st.
I'll pay it off as soon as I get out.
If you haven't paid it, you got to show up at 9 o'clock on August the 1st for a review hearing.
Yes, sir. Okay, thank you.
Okay, that's all.
All right, thank you.
You're welcome.
State of Ohio versus Derek Jenkins, case number CRA 25393, and Daryl Runyon is on deck.
All right, Mr. Jenkins, this is set for Rule 4. So you were not able to post bond.
No.
Okay, I'm going to release you, since they only want a $250 bond. I'm going to release you and order you to go turn yourself in. You've been in jail now for well,
Since the 27th of June.
yeah, so it has been a week. Okay, I'm going to release you, order you to go turn yourself in Pike County. So if you don't do it, you're still subject to there's a warrant for your arrest out there.
Yes, sir. I've already, my parents have been in contact with Pike County, and we've kind of got it all worked out.
All right, I'll order you released.
All right, thank you, sir. I'm done, though. Who's on deck?
State of Ohio versus Daryl L. Runyon, case number CRB 23529.
Bailey, thank you so much for gifting 5 memberships. Really appreciate that, and welcome to 25 new members today. You're part of a good community, so stick with it. Trust me. Anyways, again, thank you, Bailey. Really appreciate it.
All right, Daryl Runyon. You're Daryl Runyon. Sir, you're Daryl Runyon. Can you hear me? Okay, you're on. I can't hear you. You're probably turned off at the headset. They'll need to turn it on.
Okay, I believe, sir.
Now we can hear you. Okay.
Okay.
You just got out of, you were incarcerated up in, was it Chillicothe?
Yes, sir, I've been down for a year.
And you're coming back to Lawrence County now?
Well, if I do that, I'm gonna be living in Franklin County. But whatever I need to do, I'll do.
Yeah, you still have a case pending here on domestic violence from 2023. So we gotta
Yes,
deal,
sir.
we gotta deal with that. And Mr.
Okay.
Morford was your lawyer.
Yeah, I've been working on my glove cabinet too. I've got glove glasses in since I've been in gloves, and I've been off for a year. I've been off from dope for a year and 2 months.
Okay. Somebody brought in a certificate where you completed, intervention program.
Yeah,
Who brought this in?
Yes, sir, and I had to do AA and MA too, I've done that.
All right, you can give Mr. Hall, Mr. Hall, Mr. Hall.
Mr. Hall.
You can give this back to him. Just make a copy for the file, please. Okay, so what I'm going to do, I'm going to withdraw the warrant and give you another hearing date with your lawyer. Your case is still pending.
Okay, sir.
Let's set it. July 25th.
That'll work.
July 25th will be your next hearing. We'll let Mr. Morford know. And you need to get in touch with him about being here. He'll need to be here that day for his hearing at 10 o'clock.
I'll definitely be there, sir.
Okay, I'll release the warrant so you'll get out of jail today, and we'll make it a signature bond of $2,000.
Okay, thank you, sir.
July 25th is the next hearing.
I'll be here. Okay.
They say July 25th.
State of Ohio, Joseph Rollins, case number CRA 25395, CRB 25396. Tony Brees is on deck.
This is like crazy. I remember this. We had July 11th. So what's in jail?
Go ahead and move Brees down.
Yeah, Breeze is fine. We'll do that.
All right, thank you.
Sir, are you Tony Breeze?
Yes.
Mr. Breeze, I'm Judge Kapler at the Lawrence County Municipal Court. This is what's called an arraignment hearing for you. So everything we say is going on the record. You don't have to say anything, but if you do make statements, they can be used against you if you admit something about this. It's alleged, well, let me go to your rights. You have a right to remain silent, I just told you that. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove charges beyond a reasonable doubt. You understand those things? It's alleged that there's a warrant for your arrest in Delaware County, Ohio. So I've got a copy of the warrant. It's from the Common Pleas Court, Delaware County. And it says you violated community control sanctions in that court, and they wanted you arrested on those community control sanctions. And let's see. Yeah, it says case number 22CR 080454, motion to terminate intervention in lieu of conviction and impose a sentence. So that's been filed. So that looks like that's what it's about.
Okay.
So, you have a right to a hearing in this court to decide if you are the person being sought by Delaware County, if there's good reason to send you to that jurisdiction, you can have an attorney and have one appointed to represent you if you want. You won't, my decision won't be on whether you did or didn't do what you were supposed to in the intervention in lieu that you were supposed to get. It'll be whether Delaware County has a good reason to require you to come to their jurisdiction. That'll be the only issue I'll decide. You can waive that hearing if you want and agree to go to Delaware County. If you do, I'll set a bond. If you can post it, then I'll order you to go turn yourself in. If you can't post it, I'm going to order Delaware County to come get you. So how do you want to proceed? Do you want a lawyer here to talk to you about this? Do you want to agree to go to Delaware County? How do you want to go forward?
Like you said, you're still a bond, I can go turn myself in?
Okay, so you want to waive the right to a hearing here and have,
Yeah,
okay, and just have me set a bond for you.
yes.
Okay, let me look over the paperwork a little more and see. Sometimes they will tell me in the paperwork what kind of bond they're asking for, if they're asking no bond.
Okay.
Well, it said one of the reasons they're upset with you, they're alleging, is that you left, after you left residential treatment, you did not contact staff with the court and keep them posted as about what you were doing.
I was like, my daughter was sick, and she was diagnosed with leukemia, and I needed to go see her, and they wouldn't let me go see her.
They also said you left treatment without staff approval, so you left treatment without approval.
Yeah, that's what happened, because I needed to see her now, and they wouldn't let me go see her, that's why I left.
Okay.
Because she was diagnosed with leukemia, and I needed to get her into that children's hospital.
I'm going to set your, does the state take any position on bond or anything here?
No, Your Honor.
I'm going to set your bond at $10,000 cash or surety. Do you think you can post that kind of bond?
Not 10,000, I can do 10%.
Okay. I'll let you use a bail bondsman, so that's probably what it would be, $1,000. You want to talk to a bail bondsman?
I mean, I can talk to those ones, and I don't know when you're around here.
Well, we do. We've got one that does 95% of the bonds here. So, but here's the way this works. If you want to try to post bond, I'll give you some time to do that, but I'm not going to tell Delaware County to come get you, because they get in their car, start driving down here, and then you post bond, and then you're not here at the jail when they come to pick you up. So I'm going to give you a time frame to try to post bond before I start the clock running on them to come get you. You understand? So if you're not able to post bond, it may wind up you just sitting in our jail for a while you're trying to get bond together, and it never happens.
But if you keep it bail bond, then that'd be fine.
Okay, so what I'm going to do is I'll set your bond at $10,000, and I'm going to require you to post it today by 4 o'clock. You should. The bail bondsman's pretty good about getting in touch with you, so you should know today. And then if you do post bond, I'm going to make you turn yourself in next week. So you got to turn yourself in by July the 11th.
Okay.
That morning, or be in this court July the 11th at 10 a.m.
Okay. Sounds good.
So we'll send a waiver to you to sign at the jail.
Okay.
And we've already notified the bail bondsman that you want to talk to him, so he should be getting in touch with you. Is there somebody he should call on your behalf, or does he just need to get in touch with you at the jail?
I just want to get in touch with you, Jim, because everybody that I know right now is at work.
Okay. Okay, so this needs to be waiver faxed to the jail. Okay, do you understand what you need to do?
Yes, sir, I need to either get, once I get bonded out, I need to get in contact with Delaware to turn myself in by the 11th.
Yeah, get the warrant withdrawn by the 11th. Or show up here in Chesapeake and explain to me why you didn't get that done. Or we'll issue a warrant for you.
Yes, sir.
Okay, good luck.
Thank you.
State of Ohio versus Joseph Rollins at the Lawrence County Jail. Your Honor, that's the only case we have left at the jail if they have been ready.
Okay. All right, Mr. Rollins is here. Roger Smith's his attorney, but he's unavailable for that. He's been sitting in jail since Monday. So I think there was an attempted assessment of him on Monday, and he wasn't making a lot of sense of being very forthcoming. So I'm going to ask that you do another assessment of him today, and then we'll come back after you be very honest in your assessment, and I'll have you back after you do that. Okay, you're going to get a call from the treatment provider.
Okay, Your Honor. Will I get my bond back, or is it still gone?
Well, that's what we're going to figure out. I think you were still under the influence on Monday, so.
That's what I didn't have really any good memory from everything I was through over the weekend, so.
Okay, well, you seem a lot better today, so you'll get a chance, let's do it again, and this time be honest and forthcoming, and we'll see what happens later today.
Yes, Your Honor.
Okay, I'll have you back after you talk to the treatment provider.
Will I be back in the courtroom today?
Yes, sir. Yeah,
Oh,
by teleconference, you're gonna go do a phone call, then you'll come back on teleconference after you do your phone call with the provider.
Okay, yes, Your Honor.
Okay.
State of Ohio versus Caitlin Moore. Here's the court, case number CRB 24337, CRA 24243, CRB 24244.
This is Mr. Morford's case, but he's not here. I was told there was going to be a dismissal, though, is that right? Or?
Yes, Your Honor, I had a lengthy conversation with Mr. I can't think of his name, Mr. Hinkle, the alleged victim, on the some of the charges. The other charges went to the grand jury. She was actually convicted of the F4 burglary and is a star, or was a star. So Mr. Hinkle and I discussed the fact that they have children together, and he feels like the star experience and conviction in common pleas court is sufficient, and so he is not opposed to us dismissing the pending charges here, so we'll do that.
All right, so all pending charges against Caitlin Moore are valid.
State of Ohio versus Christopher D. Faulkner, case number CRA 25334, CRB 25335, A, B, and C.
Ashley gifts another 5 memberships, brings us up to 30 gifted members for the total today. Thank you so much, Ashley. As always, huge heart, and everybody in this community appreciates you, not just me. So thanks so much.
And he is due to be back for his first appointment on the 7th of this month to start services for counseling.
Okay. He does have a bond up. He's not here. He's not in court today.
Yeah, I see that he's not there.
So I'm going to go ahead and issue a warrant for him and notify Mr. Sowers, and then you can let Mr. Faulkner know that he needs to get into court as soon as possible.
Yes, I will have them reach out to him.
So issue a warrant and set a bond forfeiture for July 21st. Now I'm notifying Mr. Salvis.
State of Ohio versus Eber J. Medina, case number CRB 25392 A and B, PRC 251468. Your Honor, he was picked up by ICE.
All right, now the charges here then. Mr. Hill.
Well,
Got an OBI or you want a warrant?
assuming he's never going to come back, I would think, on the one hand, nollying would be the appropriate thing, but we never know. So yes, we'd ask for a warrant.
Okay, I'll issue bench warrant for failure review.
Your Honor, we have a couple of recalls from here. We do have a prelim, but it's Mr. Morford's case, we're still waiting on him. State of Ohio versus Alexis Destiny Smith, case number PRC 193668.
Was a request to transfer to Simpson with counseling center. Okay. Some consult about that.
Yes, Your Honor. I was able to secure her bed for Monday.
Okay, so she's going to stay at Southern Hope till then, or how?
Absolutely, Your Honor. She's done really well there. We don't want to do anything to try and stand in our way.
All right. So how can we, she come here? How are we going to get her to?
I can pick her up after court.
Okay.
Okay.
Yep, save you guys a hassle.
Okay.
All right, so allow transfer to counseling center. Set your next hearing for August 1st.
You got a card?
Yeah, 100%.
9 o'clock for review, August 1st.
Thank you.
Thank you, Your Honor.
Good luck.
State of Ohio recalls Brian Coffin, case number CRB 24330.
All right, Ms. Moore, your cases have been dismissed.
Okay.
Mr. Morford is on his way here, but and figure you object to having your cases dismissed at the request of the prosecutor.
So I'm okay?
They said your ex was satisfied with what's happened so far and didn't want to pursue it any further, so you're going to be dismissed. You're welcome. All right, Mr. Crawford is here. We're waiting on transport from ODT. They said they were going to send somebody to pick him up.
I haven't seen you.
Okay. Well, let's just have him hang out back in the back so they come pick him up. You're welcome. Yeah, let's wait for this here now, see what they say.
We're still waiting on Mr. Moore, and we're waiting
we've got 2 cases left to do. Both are being worked on, or we're waiting on Mr. Morford. He said he was on his way. Texted me he was on his way, so we'll take a recess. Court's in recess.
Well, there you go, my friends. The court is in recess right on time. I don't think I could have worked that out any better. I hope you all had fun today. I know I did. Dungeon Court is definitely proof of the multiverse theory. Yes, it is, Michael. It's kind of become a little bit of a guilty pleasure for us here, hasn't it? But that's okay. It's good to do things different from what you might see every place else. Oh, you gonna come say hi now? All right, come here. Don't step on the keyboard. Don't end the stream early. Say hi. Snuggle up to the mic. You usually like that sort of thing. I know. I brought her in and then she's just been napping. So, but you came just in time because we don't get to see these people again until Monday. Will you snuggle up to the mic? You know they're out there. Yeah. Never let it be said that Ellie doesn't love all of you. Literally, when I'm not streaming, I'm in here working. She will come in here and do what she's doing right now and just snuggle up to the microphone. So she's figured out that there's something going on. Obviously, she doesn't totally understand it, but I think in her own way she does. So anyways, we obviously won't have a show tomorrow for the 4th, so everybody have a good 4th of July. Be safe, have fun, all that sort of thing. We will be back Monday, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members for the pre-show. I do reserve the right to show up at some point this weekend. I'm not saying that I will. A lot of it will depend on how the weekend goes. But I reserve the right to pop up someplace somehow. So keep an eye on your notifications. If you don't have the notification bell turned on, do that. And we'll just see what happens. But again, appreciate all of you. Thanks so much for everybody's generosity today and the good time we had in the chat and everything else. It's been a fun week. But again, see you Monday, if not a little sooner. Take care. God bless.